Good afternoon, everyone. Just going to give people who are still joining a minute or two, and then we'll crack on. So just bear with me. Thanks. Okay, I think we'll make a start. You may hear some pinging in the background as people ask to be admitted, but bear with me. Thanks very much for joining me today for this Law with Lunch session. I'm afraid it's quite a dry topic, but at least, if nothing else, you're going to get some CPD points from it. You're all muted for the talk, but hopefully there'll be time for some questions at the end if needs be. And the talk's probably 45 minutes to an hour. I won't be offended if you need to leave or choose to leave. Just a quick introduction to me. I'm Tom Nossiter. I'm a barrister specialising in personal injury. I work for claimants and defendants, generally multi-track, but some fast track, and of course now intermediate track cases and disease as well as general PI. Today's session is aimed at both claimants and defendants, and it's called Drinking in the Last Chance Saloon. And it's about bringing a second personal injury claim after a failure of service in the first claim and the Section 33 applications which often follow. I often refer to these second personal injury claims as second action cases, but I think that's my terminology rather than anything formal. So hopefully you can all see the PowerPoint presentation. The first slide, scenarios, seeks to explain what I mean by second action cases. The scenarios usually involve a claimant in a personal injury claim issuing a claim form. And as you know, Rule 7.5 says the claimant has 4 months after issue to serve that claim form. And then one of three things usually happens. The first scenario is the claimant, and I'm assuming solicitor service here, attempts to serve the claim form and usually all the relevant documents, particulars of claim, medical reports and so on at the same time. And service isn't effected within the relevant 4-month period because service was on the wrong address. So, for example, I had a case where a defendant was served at an address that was similar to, it wasn't this address, but it was similar to flat 1, 30 Station Street. And the actual address was flat 1, Smith's Court on Station Street. Again, that's not the actual address, it's a similar address. And so service wasn't affected upon that defendant. Another scenario might be where the registered office of the defendant has changed shortly before service and the claimant hasn't done an up-to-date Companies House search and discovered that. And then in this scenario, the claimant doesn't appreciate the error in the service address until after the 4-month period for service has expired. The second common scenario is the claimant serves the claim form at the correct address for the defendant, but usually because of an error in calculation of time or diarising, service is affected a few days after the 4-month period. And then the third scenario is where, for some reason, the claimant simply doesn't serve the claim form at all within the 4-month period, and this only comes to light when it's too late. Now, believe me, all these scenarios do happen, and they're not that uncommon. As you'll hear, there's quite a lot of case law which demonstrates this. And my personal experience, I think I've probably been involved in about 25 cases based on these scenarios in the last 10 or 15 years or so. So those scenarios are what happens in relation to the first claim or proceedings. And the question then arises as to what can or should the claimant do. Sorry about all the pinging. Hopefully it'll stop soon. What can or should the claimant do to attempt to address the problem which has arisen? And what can the defendant do to defend its position? Ignore for now the obvious possibility that there might be an alternative claim by the claimant in professional negligence against the claimant's solicitors. I'll talk about that later. And assume the claimant wishes instead to continue against the original tortfeasor. So often what happens is that the claimant decides to issue a second claim form and attempts to pursue the second set of proceedings, hence my phrase, the second action cases. Usually, of course, a claimant has only issued the first proceedings close to or on the cusp of the expiry of the limitation period, and that often means that in the second action, limitation issues, particularly Section 33, arise, and that's why I deal with Section 33 here as an interaction with the second action cases. So this talk is going to be a fairly whistle-stop tour of the rules and the case law and the considerations which are relevant and arise in these scenarios in second action cases and in relation to limitation. Just to put things in context, a few general rules and useful points. Of course, most personal injury claims now have to be brought through the DCP, the Damages Claims Portal. There are still situations, though, where claims shouldn't be brought through the DCP. Practice Direction 51ZB tells us what those situations are, but particularly relevant here might be situations where perhaps you have two defendants and one is a litigant in person, not legally represented, of course, that means. So you might have a road traffic claim where the driver, first defendant, isn't insured at the time of the accident, and the MIB are involved as the second defendant under the uninsured drivers agreement. And of course, the MIB only has a contingent liability to satisfy any judgment obtained against the first defendant which isn't satisfied. You might have other RTA claims, perhaps where the defendant driver isn't being indemnified by the RTA insurer. So the driver is a litigant in person and the insurance company is sued as second defendant. In these examples that I've given, you can't use the DCP because the defendant has to be legally represented for the proceedings to be brought against him in the DCP. So the talk is probably a bit more relevant to claims not brought through the DCP, but by extension, some of the arguments I discuss here and some of the rules also apply in the DCP because, for example, in PD 51ZB, rules 3.3 and 3.4 essentially echo the rules in rule 7.5 and 7.6 of the CPR that I'm going to talk to you about now. So the next slide, CPR 7.5, that tells us just what we all know. The claim form must be served by midnight on the calendar day 4 months after the date of issue. Now that time limit is strictly observed by the rules. You'll know, of course, there's a perhaps a less strict approach to extension of time for service of particulars of claim, but that's not part of the subject of this talk. Next slide. So rule 7.61 and 2. 7.61 says that if you want to apply for an order extending the period for compliance with rule 7.5, you can do, But the general rule is the application should be made within the 4-month period specified by Rule 7.5. So general rule is make a prospective rather than a retrospective application. And such applications are likely to be relatively straightforward for the claimant. The problem comes with Rule 7.63, which is what we often have here. So if the claimant applies for an order to extend the time for compliance after the end of the period specified by Rule 7.5, 7.63 says the order can only be made by the court if these criteria are satisfied. So either the court has failed to serve the claim form or, and this is key, the claimant has taken all reasonable steps to comply with Rule 7.5 but has been unable to do so. And in either case, the claimant has acted promptly in making the application. So there's lots of case law about 7.63, and most of it turns on subparagraph B, the interpretation of reasonable step taken by a claimant to effect service within the 4 months. And these cases show that the courts are strict about what constitutes reasonable steps. So quite an old case now, Venus against Marks and Spencers. There, the defendant had admitted liability and had made interim payments, but the claimant solicitors served the claim form a week out of time, and in their evidence in support of the application, they didn't give any good reason for doing so. And so the court reached the conclusion that the claimant hadn't shown that it had taken reasonable steps to serve, and retrospective extension of time was not permitted. The next case, Nangligan, just bear with me. Nangligan, similar. The defendant had nominated solicitors for service, but the claimant solicitors inadvertently served on the defendant itself. They realized their mistake, but they didn't take steps to correct it within the 4-month period, and the court concluded that reasonable steps under 7.63b had not been taken, and the time for service wasn't extended. These are some important notes about 7.63. Firstly, as you'll know, there's a power under Rule 6.16 of the CPR to dispense with service. But the case of Lacey against Palmer says that where you have a situation where the claimant's failed to serve the claim form in time and making a retrospective application, the only way to remedy the situation is the Rule 7.63b test. The court can't dispense with service to circumvent that rule. Relief from sanction, Haley and Siddiqui is authority for the proposition that Rule 3.9, the relief from sanction test, isn't the test which governs 7.63. It's its own test. And then notes about discontinuing proceedings. The case of citation against Ellis is an interesting case. The first question is, when is a claim commenced or started? This is obviously relevant because you can't discontinue a claim which hasn't been started. So is a claim commenced when it's issued but not served, or only after service? Well, Mr. Justice Tugendhat in citation concluded that if the claim form is issued but never served, the proceedings have still been commenced. They're not a nullity. Secondly, if a claim has been commenced, in what circumstances does a claimant formally have to discontinue the claim by filing a notice of discontinuance under 38.3? Well, there's a footnote in the textbook Zuckerman on Civil Procedure Principles of Practice, which suggests that the claimant's obligation to pay the defendant's expenses arises only once the claim form has been served, because until such time the defendant does not have to take steps to defend the claim, and the need for service of a notice of discontinuance and the right to cost thereafter can't arise before service. That would seem to suggest you don't need to serve a notice of discontinuance if proceedings have been issued but not served. But in the light of the citation case, I'm not convinced that's the correct position anymore. And I'd also treat those comments about a claimant not having a liability for the defendant's costs if proceedings haven't been served with caution. Section 51 of the Senior Courts Act 1981 says that the costs of and incidental to proceedings shall be in the discretion of the court. And in citation, it's paragraph 28 of Mr. Justice Tugendhat's judgment. He concluded that where proceedings had been issued but not served, costs could still be payable by the claimant to the defendant, because the words incidental to the proceedings in Section 51 of the 1981 Act were to be interpreted as including costs of complying with pre-action protocol procedures. Tactically, a claimant might decide to serve a notice of discontinuance even if proceedings haven't been served, although they've been issued, because as you know, under Rule 38.61, a claimant who discontinues a claim is liable for the costs which a defendant against whom the claimant discontinues incurred before the date of the notice of discontinuance. But that, of course, is subject to the Quox provision, so it's not an enforceable cost position. If a claimant doesn't serve a notice of discontinuance, it seems to me, in the light of Mr. Justice Tugendhat's decision in citation, that the defendant might look to strike out a claim form, even if it hasn't been served, because the proceedings have been started. And of course, if strikeout is ordered, then that's an exception to Quox under Rule 44.15, such that a defendant might well get an enforceable costs order against the claimant. Right, so those are background remarks or thoughts. Now let me go to the scenarios about defective service of the claim form. Bear with me. Just to let someone in. Okay, so the claimant's problem and the potential solution. Well, the problem is, as outlined earlier, the effect of Rule 7.63. The potential solution for a claimant is to commence the second action and, if necessary, make an application under Section 33 of the Limitation Act. The reason the problem rises under 7.63 is, as I hope I've made clear, sometimes there's just no way for a claimant to get round the 7.63 test. If the claimant issued the claim form and took no steps to serve it at all, or serve but at the wrong address without making reasonable checks about that address, then it's unlikely a court is going to accede to an application under 7.63. So realistically, a claimant might not have any option apart from to commence the second action, save, of course, the potential claim against his or her solicitors in negligence. So some of you might be thinking, well, this sounds like it might be an abuse of process scenario. There's some helpful and detailed commentary at note 7.6.9 of the White Book. But in short, the answer is generally no, it's not an abusive process. Actas and Dixie, which were conjoined appeals, are helpful cases here. In both cases, the first claim forms were issued within the limitation period, but weren't served within the 4-month period. And both claimants issued second claim forms relying on Section 33. The defendants argued the failure to serve the first actions was a misuse of procedure, an act of disrespect to the court, and tantamount to abuse of process. And the only fair response was for the second action to be struck out as a further abuse of process. But the Court of Appeal said, no, that's wrong. A mere negligent failure to serve the first claim form in time isn't an abuse of process. Now, of course, that phrase mere negligent failure is to be distinguished from other more serious disregard scenarios. But a single negligent oversight in timely service, as opposed to inordinate and inexcusable delay or intentional and contumelious default or wholesale disregard of the rules, that's the distinction the Court of Appeal draws. And the Court of Appeal said there's nothing in the case law which says if there's still time to start a new claim by second claim form, and in this case we mean with the Section 33 discretion operating, there's no reason why that can't be done, the Court of Appeal says. So what about discontinuance and the subsequent proceedings and how they interact? Well, the first thing is just to draw your attention to Rule 38.7 of the CPR. It doesn't always apply, but what if the claimant has commenced proceedings against two defendants and validly served one of those defendants but not the other? And the validly served defendant has filed and served a defence. So you might have, my scenario earlier on about the litigant in person and the MIB. What if service is defective on the litigant in person, but validly served on the MIB, and the MIB files and serves a defence before the issue about service on the first defendant becomes apparent? Well, as I said earlier, the claimant can't or shouldn't continue only against the MIB because the MIB only has a contingent liability. So the claimant really needs to start again against the litigant in person and the MIB. Rule 38.7 says that a claimant who discontinues a claim needs the permission of the court to make another claim against the same defendant if they discontinued the claim after the defendant filed a defence, and if the second claim arises out of the same or substantially the same facts as the first discontinued claim. And Rule 38.7 at subparagraphs 2 through to 5 go on to explain the procedure to be adopted, but essentially the claimant has to ask for permission to pursue the second claim in the claim form. The defendant then responds indicating whether it consents or opposes, and then the court will determine the application on paper or by way of a hearing. And the test is, well, the court has a discretion. There's no fetter on the discretion imposed by the rule 38.7. But of course, the court will probably have a natural disinclination to permit the claimant to commence a second claim against the background of a previous discontinued claim, unless there's a sufficient explanation for why this situation has arisen. There's some helpful case law. Wickham and Riley, that says the application should be considered with the overriding objective in mind, dealing with cases justly. Western Power Distribution against Southwest Water. The court is to look at all the circumstances in the round, and it's for the defendant to show why it's manifestly unfair to allow the second claim to proceed, especially where the first claim has been discontinued at an early stage and there is sufficient explanation for that. There's a qualification to those words manifestly unfair in a case called Astley against Mid Cheshire. Where it's said that manifest unfairness or unfairness is only one factor to fall within a broad merit-based judgment. Wickham and Riley has a useful summary of the principles, but in short, when applying the overriding objective, the factors to be considered include: was the first claim dismissed or discontinued? If discontinued, usually the second claim will have a better chance of being allowed to proceed than if it was dismissed. That's subject to that point about quox, of course, and the costs implications that follow. Other factors: are there any changes in the law? Has any important new evidence come to light? To what extent were court resources already used up dealing with the previous claim, any abuse of process, the public interest in the finality of litigation, and the merits of the underlying claim. Back to Quox for a moment, and what I just said in relation to dismissal or discontinuance. There's a tension, it seems to me, between the cost protection that discontinuing the proceedings provides to a claimant in relation to those first proceedings and the prejudice a defendant can argue it has suffered when arguing about whether the second action should be permitted to proceed. The defendant will say, well, the claimant discontinued the first proceedings and we weren't able to recover our costs of those proceedings by reason of Quox. This isn't fair. The claimant shouldn't be allowed to proceed in the second claim. So, rhetorical question here. Tactically, should a claimant offer or agree to pay the defendant's costs of the first proceedings, even if they're not enforceable under Quox? Or should a claimant invite the first proceedings to be struck out so as to create an enforceable costs order and give itself a better position in the second proceedings? Confess, I'm not sure what the best answer to this is. And of course, those first proceedings costs are going to have to be found from somewhere if they're to be paid. So, issuing the second claim and a broad overview about a claimant's prospects of success. Firstly, it seems to me the more promptly the second claim form is issued, the better the chances of being allowed to proceed with the claim form from the claimant's point of view, not least because there's likely to be less delay after expiry of any limitation period that way. There's a spectrum of likely outcomes and difficulties for a claimant in these scenarios, and that spectrum, or where on that spectrum the claimant falls, depends on various matters. But what happened in relation to service of the first claim form, and what were the reasons for that? I mean, they're usually not going to be good reasons, but of course there's probably a spectrum of bad reasons, and really bad reasons for not serving the first claim form are probably not going to be helpful to the claimant's cause. Other factors, limitation arguments. When were the first and or the second claim forms issued in relation to limitation? Whether the defendant had served a defence in the first proceedings, so that there's an additional hurdle for a claimant to get through under Rule 38.7. Has there been delay in proceeding with the first claim and or the second claim, to what extent? And arguments about costs and other prejudice touched on earlier. So in conclusion, my experience is the outcome of these cases is very much fact, and I think in fact very much judge specific. Some judges are likely to be much more sympathetic to the plight of a claimant or a defendant than others here. Turn to Section 33 of the Limitation Act. This part of the talk isn't just relevant to second action cases, but to any personal injury claim or disease claim issued outside the primary limitation period. And just going back to basics, the general rule is, in personal injury claims is the claim has to be brought within 3 years of either the cause of action, which usually means the accident, or the date of knowledge, if later. In personal injury claims, Section 33 of the Act gives the court a discretion to direct that that 3-year limitation period shouldn't apply to the claim. Firstly, what's the procedure for making a Section 33 application? I've given you the reference there to the White Book. Sorry, it should say 2026. It's the same reference in the 26th version of the book. But this confirms that there's really no specific procedure, and in particular under the Act, in relation to how the power under Section 33 is to be invoked. The case of Richards and McEwen in the Court of Appeal, the Court of Appeal held that it would be sufficient simply to raise a Section 33 application in the reply to a defence, and a formal application by way of Part 23 was unnecessary. Bearing in mind, limitation as a defence is a shield, not a sword. In other words, the defendant can raise it if it wishes to do so, but it doesn't have to. And the defendant might raise limitation for the first time in its defence, and that might be why a claimant then responds in the reply. But often a claimant will anticipate the limitation argument, particularly in a second action case, I suppose, and plead to limitation in the particulars of claim, perhaps setting out arguments about date of knowledge, contending limitation hasn't in fact expired, in the alternative seeking a Section 33 direction. And the claimant might do this to try and persuade the defendant not to raise the limitation defence. So in cases I've pleaded, my tactic sometimes has been to say, we accept that limitation has expired, but liability has admitted. We've only commenced proceedings perhaps a few days outside limitation. There's no prejudice to the defendant arising from this delay, and we invite the defendant not to raise the limitation defence. And sometimes defendants take that approach, appreciating that in the particular circumstances of that case, the limitation defence and the defence of a Section 33 application is unlikely to be successful. Next, when should limitation issues, and in particular a Section 33 application, be determined? Well, the White Book at note 8-94 tells us that the decision about this should be made at the case management stage. Of course, it's fact specific. Some cases are ripe for a determination of limitation at a preliminary, or perhaps I should say interlocutory stage early on, or as a preliminary issue for trial, or as one of all the issues to be heard at the substantive trial of the matter. Matters such as the potential savings in costs, time and court resources, or not, might be relevant there. Now, I think you'll all be familiar with Section 33, and I've simply, sorry, bear with me. I think I've set out here Section 33(1). This is the crux of the test. Essentially, what the court is required to do is perform a balancing act to determine, is it equitable to allow the claim to proceed or to prevent the claim proceeding, having regard to how the decision will impact the parties involved. Section 33(3) expands on that balance of prejudice test. It sets out what factors the court should have regard to when making its decision. And you'll see in the opening sentence all the circumstances of the case, and then in particular to 6 factors, which are set out here at A to F. Now, if any of you aren't familiar with Section 33(3), I'm sure you can read it in your own time. Here's some useful case law about Section 33(3). Firstly, what's the relevance of relief from sanction case law when considering whether to exercise the Section 33 discretion? Well, Ellis against Heart of England says that the court shouldn't import into a Section 33 application the case law which deals with Section 3.9, including Mitchell and Denton. And then The following cases listed there, Horton, Actas, Leeson, and Kane, they give you some, I think, broad statements of principle which touch on how the courts should deal with the respective prejudice to the parties, the cogency of evidence, this is arising from delay, the relevance of an alternative potential claim in professional negligence that the claimant might have against his or her solicitors. I'm going to skim quickly through these cases. You've got the citations, and no doubt you'll read them in your own time if needs be. Horton and Sadler, and in particular I'll refer you to paragraphs 21 and 22 and 44 of the judgment, is authority for these propositions. Firstly, the question for the court under section 33 is always whether it's equitable or inequitable between the parties to override the time bar. Secondly, the section 33 discretion is broad and unfettered, and the practice of the courts has regularly been to exercise the discretion in favour of a claimant in cases where the defendant can't show that he has been prejudiced by the delay. No matter how negligent the claimant's solicitors may have been in the simple skills of keeping a diary, the plea of limitation which the statute confers upon the defendant is, in the absence of forensic prejudice, properly described as a windfall of which the defendant can be deprived. That's paragraph 44 of the judgment. Actas and Adepta we talked about earlier, and I drew to your attention the distinction between mere negligent failure scenarios where that's the explanation for failing to serve the first claim form in time, and more significant defaults such as inordinate and inexcusable delay. Paragraphs 44, 45, 47, and 90 through to 93 are very helpful in relation to those matters. You might also want to have a look at paragraph 95, which talks about the impact of the failure of the first action and the consequential effect on a costs order, because of course that might now be affected by Quox. Actus is a pre-Quox case. And then in relation to the possibility of an alternative remedy against a negligent claimant solicitor, what's said in paragraph 96 of Actas is that the possibility of the alternative claim against the solicitor might be relevant to an argument about the balance of prejudice. And it's relevant to the exercise of the section 33 discretion, but such an alternative remedy is generally an unsatisfactory way of litigating a claimant's claim, and it does little or nothing for the court's limited resources. More of that a bit later. Leeson and Marsden, well, I think things to draw here. Paragraph 174, on a section 33 application, the cogency of the evidence to be adduced or likely to be adduced by the defendants was, in that case, was unlikely to be adversely affected by the delay since the expiry of the limitation period. Medical records relevant to the action were still available, and the defendants had had the opportunity in that case within the limitation period to investigate the claimant's allegations fully and to take witness statements, and that meant a fair trial was still possible. And then at paragraphs 199 through to 202, there are further helpful comments, well, helpful to a claimant solicitor, I suppose, dealing with what significance should be attached to a potential alternative claim in negligence. But the point in short is made that claimant solicitors know the ins and outs of the claimant's case and the strengths and weaknesses. And so when a claimant brings a professional negligence claim against his solicitors, the claimant probably loses the chance of recovering the full value of the claim as it might have been against the defendant, and rather the claim in professional negligence would be assessed on a loss of chance basis to reflect the risks which the claimant faced in the original claim of not succeeding, which of course the claimant solicitors might have been alive to. Finally, Kane and Francis. Where a defendant has early notice of a claim, even if the claim isn't then served, or issued and served, I should say, until after limitation has expired, the accrual of a limitation defence should be regarded as a windfall, and the prospect of its loss by the operation of the Section 33 discretion should be seen as either no prejudice to the defendants at all, or only a slight degree of prejudice. Whether it's fair and just to allow a claim to proceed is the heart of Section 33. And in fairness and justice, the original tortfeasor ought only to have the obligation to pay damages removed if the passage of time had significantly diminished the opportunity to defend himself on liability and or quantum. Other helpful comments in Kane about the length of the delay in bringing the claim after limitation isn't a deciding factor. It's the effect of that delay and whether there's evidential or forensic prejudice which make the difference. And then just some further comments about potential negligence claims against solicitors. In Kane, there's reference back to a case called Furman against Ellis from 1978, where Lord Denning observed that it was a matter of simple justice that the original tortfeasor's insurers should pay the damages, and not the insurers of the solicitor who made the procedural mistake, which hadn't caused any prejudice. It's the defendant's insurers who had received premiums in respect of that risk, and so it subject, of course, to any forensic or evidential prejudice. It still might be fair and just for them to meet the claim. So Section 33 discretion, as it's exercised, it's a broad and unfettered discretion. I'll turn now to the 6 factors, and in fact I've really only got anything to say about, I think, 3 of them. So subsection 33(3)(a), the length of and the reasons for the delay on the part of the claimant. Well, whereas in all the circumstances of the case test at the start of section 33(3), the court can be concerned with the full period of delay, including the limitation period. Section 33(3)(a) here is only concerned with the delay after the expiry of the primary limitation period. That's made clear in Thompson and Brown at paragraph 751. Perhaps it's page 751, I think, through D through to E. And as I told you moments ago, in Kane, it's not the length of the delay that decides matters, it's the effect of the delay. Other considerations or reasons for the delay. Was it the fault of the claimant personally? Was it the fault of his solicitors, or perhaps it was both? But there is case law, Dasanganju there, and RE against GE, which tell us that there's no rule of law that the solicitor's fault should be visited on the claimant, and that sometimes a claimant can shelter behind errors on the part of its legal advisors, although that's not always the case. 33B, the effect of the delay on the likely cogency of the evidence in the case. I think this is the crux, really, of the Section 33 test. Relevant considerations, they might include what are the outstanding issues in dispute between the parties. If liability is admitted, and we're only talking about a causation quantum dispute, then the cogency of the evidence available might still be strong because there might still be medical records from the time of the accident onwards. There might be medical reports which were obtained within the limitation period. Other thoughts? So, what opportunities did a defendant have to investigate the claim within the limitation period? There might have been a claim notification form or a letter of claim or an MIB claim form sent soon after the accident, for example, and the defendants might have investigated, obtained evidence, or perhaps even obtained witness evidence or witness details, and that evidence might still be available. And that's obviously going to be relevant to the ability of the defendant to defend itself in the case. There's some relevant case law. Well, I'm sure there's more than just what I'm going to give you now, but FZO, I think this is authority for proposition, which I think is a court needs specifics about prejudice and loss of cogency rather than general averments that because there's been lots of delay, the evidence is likely to have significantly been affected. In FZO, the defendant argued it had been prejudiced by the absence of witnesses, but it was unable to give concrete examples of missing witnesses or explain the efforts made to locate witnesses or indeed identify witnesses who it had attempted to locate but not found. And the judge at first instance found that the defendant had not evidenced proper investigations to attempt to address its allegedly missing evidence, and the Court of Appeal agreed. On the next slide, there's a case called Azam, which covers similar ground. Just expanding on the point about the defendant's evidence and proving efforts. Where a defendant thinks it's prejudiced because of evidence being lacking or missing due to the passage of time, it might well be important for a defendant to establish the point in time when that prejudice probably arose. Ideally, a defendant's going to want to demonstrate that it arose after the expiry of the limitation period. So, for example, thinking particularly of disease cases here, but relevant watershed dates for the destruction of defendant evidence might be when a company became insolvent. So you might be able to ascertain dates of the appointment of administrators, the date of liquidation, when it was struck off the company's register. The date of closure of the particular site might be relevant. These events are likely to paint a picture of when the evidential prejudice occurred and the extent of it. Those arguments, though, the other side of the coin, if you like, is that they might work in favour of a claimant. If a claimant can successfully argue that the evidential prejudice to the defendant arose before the expiry of the limitation period, then a claimant can argue that the delay in commencing the proceedings after the expiry of limitation might not have made the defendant's job of defending the claim any harder. That's a little bit of an oversimplification of what Mr. Justice Mann said in the appeal in Gregory and Haynes Limited. If you have a look at that judgment, paragraphs 24, 25, and 27 are very helpful, but essentially that argument was a powerful factor for the judge at first instance and upheld on appeal, deciding the Section 33 discretion should operate. Another thought for you, because a defendant might be in the position of trying to prove prejudice by reason of the loss of evidence that it would have had if the claim had been brought earlier, but now doesn't have, it might be necessary for a defendant to show it's prejudiced in being able to evidence the prejudice. That case, Kimathi, at the bottom of the list there, dealt with this situation. The claimants argued that without knowing what documents would have revealed, and therefore being able to know to what extent they would have covered the matters pertinent in the case, the defendant couldn't show prejudice. Lord Justice Longmore, at paragraph 11 of the judgment, rejected that claimant's argument and said, quotes, if the defendant is prejudiced in being able to show prejudice, that in the circumstances of this very old case is quite enough. I've mentioned Azam. That's essentially repeating the proposition that bare assertions about loss of cogency aren't enough. And then McArdle and Marmion, there was a 17-year delay, which was described as inexcusable and unjustified in commencing the PI claim arising from an RTA. But the claim was allowed to continue. Section 33 application was acceded to because a wealth of evidence had been gathered close to the accident date, and that meant that the passage of time hadn't significantly diminished the defendant's ability to defend himself, and it was fair and just to disapply the limitation period. Section 33(3)(c), conduct of the defendant after the cause of action arose. This overlaps really with the points I've been making about availability and cogency of evidence. In Hammond, the defendant health authority had destroyed patient medical records, including those of patients it knew to be contemplating negligence claims, whose solicitors had requested the notes. They'd simply been destroyed as per the defendant's system after they became 3 years old. And the court found this significantly reduced the prejudice argument that the defendant raised in relation to Section 33. In relation to subsections D, E, and F, I really don't have anything to say. There's lots of helpful commentary in volume 2 of the White Book. It's section 8, which deals with limitation. Other matters relevant to the exercise of the Section 33 discretion. As I said earlier, the period before the expiry of limitation, of delay, or affliction of time might be a better phrase, is relevant. So the period might be well over 3 years because, of course, the claimant might not have knowledge of his injury until many years after the exposure. Let's say it's a disease case, and that's a matter which can be taken into account. Overall length of delay, again, same point really, but although I've said to you that courts like specifics rather than general averments about prejudice, McDonnell is authority for the proposition that the longer the delay, the more likely and the greater the prejudice to the defendant, subject, of course, to what the issues are and what evidence there is still. But it's an argument which I think at a sort of visceral level appeals to judges. Really long delay, so we must have been prejudiced, judge. Donovan and Gwentoys, that's again just authority for the proposition that the court should look at all the circumstances. And then the apparent strengths of a claimant's case, Leeson tells us this, but the court can take into account the apparent strengths of the claimant's case. And so, for example, if liability is not in dispute, that might well be an argument that assists a claimant. And then the possibility of a negligence claim against the claimant's own solicitors. I've already touched on this in quite a lot of detail. The four cases listed there all address the matter. But in short, the courts take a bit of persuasion that a satisfactory answer on its own to the Section 33 application is, well, the claimant's got an alternative claim against his or her solicitors. And that's partly because of the loss of chance point I made earlier, and partly because, well, it creates potential satellite litigation, and so it doesn't really assist in relation to the use of court resources. The claimant could pursue the original tortfeasor in the second claim, or they could sue their solicitors, but both claims might well end up using the court resources. Balance of prejudice test. So back to where we started. Essentially, the court weighs up the prejudice to the parties of its decision on the Section 33 issue, and it's only if the defendant will suffer real prejudice rather than the simple loss of a windfall limitation defence that the Section 33 defence has good prospects. I'm putting it the opposite way around to the bullet point, but essentially a claimant will have good prospects if the defendant's only prejudice is the loss of a windfall defence. That's the end of the talk. Thank you very much. I hope you're still all awake. My email address is here, should anyone have any queries. I'm going to try and unmute, but I might not be successful. Bear with me. I think the problem is that someone else in Chambers is the administrator, and so I can't unmute. Can I suggest this? If anyone has any queries, drop me a line by email or give me a call in Chambers, and I'll try and address them. Thank you all very much for joining me. I hope it's been useful.